become CA from Sangareddy. Today I am going to tell about discharge of contract. First of all, we know about contract. Contract is nothing but it is an agreement which is enforceable by law is contract. Further know about discharge of contract. A promise, a set of promise which makes the consultation for the each parties and other parties. For example, two persons are there, Ram and Shyam. Ram has to sell his house 40 lakhs rupees and Shyam promised to pay the 40 lakhs. So there is a contractual relationship between created these parties. When the contractual relationship is cancelled or terminated is known as discharge of contract. Discharge of contract has 6 modes of contract. There are 6 modes of discharge of contract. The types are by the performance, by the agreement, by the impossibility of performance, by the lapse of time, by the operation of time, by operation of law, by the breach. By the first one, by the performance. The performance is nothing but the fulfill of the obligation within the period of time within manner prescribed. This is the main usual way of the discharge of the contract by the performance. Second one, mutual agreement. Mutual agreement is nothing but a contract is terminated with a mutual consequence is known as mutual agreement. There are ways. Navigation. Navigation is the old original contract. Old contract is entered into the new consequence is known as navigation. Second one, rescission. Rescission is a cancellation of contract by the parties and all parties. Alternation. Alternation is nothing but change one or more terms of contract, mutual contracts. For clearly said about this, alternation is a change of terms of the parties, but no the changes of parties. For example, A has entered into the business with B has a selling of 1,000 bales of cotton in month of July. Later they both agree to postpone the date on July month. So the party has no change. The terms are the change. Dimension is nothing but is expected lesser degree of consequence is known as dimension. Next one, ways. When the parties forgives the rights. When the parties forgives the rights to enforce the contract generally occurred after the party fails to perform to other party forgives the rights to enforce while is called waves. Next one, impossibility of the performance. Destruction of subject matter of contract. Subject matter of contract decided without any fault of other parties. Non-existence, non-occurrence of particular state of thing. Sometimes contract have entered between the two parties based on the occurrence. And particular state of thing, instead of state of things, the occurrence may be occurred or does not occur can be discharge of the contract. And next one, death or personal incapacity of the parties. The contracts may be discharged by illness of incapacity of death of parties. Next one, change of law. Change of law means change of law takes place after the subsequent forming of contract. On the forming of contract is maybe impossible, the contract will be discharged. Next one, by lapse of time. Lapse of time is nothing but it is easily to understand that it is not performed without period of time. So the promise to fail to take action against within the period of time. Next one is operation of law. Operation of law is many several conditions may be arised. In operation of law, death of promisor. In the death of promisor, two conditions or two situations may arise. The two situations may arise means the person may have personal skills or knowledge, ability for the discharging of contract. For example, X has to pay the Y for the payee. In middle of their contract, the X has been done. The contract will be discharged. Next one, insolvency. Insolvency is nothing but discharge of liability from other parties. Next one, multinational authorized and alternation. Multinational authorized which make the contract authorized without consent of other party is known as multi-authorized alternation. Next one, major. Major is nothing but inferior rights get converted into the superior rights in same person. For example, A has to take B house from lease for 15 years. After the expiry of the 15 years, he buys the B house. So the inferior rights getting converted into the superior rights. Next one, by the breach. Breach is by the unscriptary. Unscriptary means before of the time. Automatically is due to the performance, due to the date.